Hill v. Baxter, 1958, is a seminal case in English criminal law, primarily known for establishing critical guidelines on the defense of automatism. The case explores the boundary between criminal liability and acts committed unconsciously, clarifying that a person can only be convicted for a voluntary act. Hello and welcome to Landmark Case Laws Simplified. Buckle up as we explore the fascinating world of Hill versus Baxter together. The case concerned the defendant, who was driving a van in Brighton. He ignored a halt sign at a junction, collided with another vehicle, and his van eventually overturned. At the hospital, he claimed to have no memory of the incident, asserting that he must have experienced a blackout due to a sudden illness. He was subsequently charged with dangerous driving. At the magistrates' court, the defense argued that the defendant was not conscious of his actions and was therefore incapable of forming any intention regarding his driving. Despite the prosecution's case that he must have been driving with some skill to have reached the junction, the magistrates accepted his claim of unconsciousness and acquitted him. The prosecution appealed to the Queen's Bench Divisional Court. The key legal issue was whether a state of unconsciousness could absolve a driver of liability for dangerous driving, an offence of strict liability. The Divisional Court, led by Lord Goddard C.J., held that while the defence of automatism exists in law, it was not made out on the facts of this case. The court established that a person is not criminally liable for acts carried out in a state of non-insane automatism because their conduct is considered involuntary, effectively negating the actus reus, the guilty act, of the crime. Lord Goddard C.J. ruled that there are situations where the driver would be in such a state of unconsciousness that he could not be said to be driving. This principle means that if an act is entirely involuntary, such as a spasm, an act during sleepwalking, or a reflex action, it cannot form the basis of a criminal conviction. However, the court placed significant limitations on this defense. The defendant must provide sufficient evidence, nearly always medical, to raise the issue of automatism. Critically, the court distinguished between cases of total unconsciousness and those where the driver had prior warning. The defendant had driven a substantial distance without incident, leading Pearson J. to note that he was driving with skill, which implied some level of conscious control. Furthermore, if the state of automatism is self-induced, for example, by driving while tired and subsequently falling asleep, it will not excuse liability. The court invoked the famous hypothetical of a driver attacked by a swarm of bees, which would cause a sudden, unforeseeable loss of control, as a genuine example of automatism, in contrast to a driver who simply ignored the warning signs of drowsiness. The court ultimately allowed the appeal and ordered a retrial, where the defendant was found guilty. The enduring legacy of Hill v. Baxter is its authoritative statement of the law on automatism. It established that while a complete loss of consciousness can be a valid defense by negating the voluntary nature of the actus reus, the defense is not available if the condition was self-induced or if the defendant had prior warning of their incapacity. The case remains a cornerstone for understanding criminal liability for involuntary conduct. Thanks for watching.